Good afternoon, everyone. My name is Sakshi Solanki, and today I will be taking a lecture on emergency provision under Indian Constitution. Before starting with the provisions which are mentioned under the Indian Constitution, let us first understand the meaning of emergency. In what do we understand by emergency in layman language? Not the legal person. If we ask from a legal person, he will explain you the meaning of emergency according to the provision of law. But what is the meaning of emergency? The plain meaning of emergency. The word emergency can be described as an unexpectedly occurring situation that causes public authorities to act instantly within their particular power. An emergency is due to breakdown of administrative machinery that triggers or allows the government to urgently respond. So by this we understood that emergency is an unexpected situation that was not foreseen, the situation that was not expected in the mind of people. So in that situation, it gives it gives power, or the authority has to act instantly, immediately. According to Black Law Dictionary, emergency demands urgent intervention and imminent warning because such a circumstance poses a danger to public and liberty within the region. Emergency steps are a peculiar aspect of Indian Constitution which enables the center to assume expansive power to deal with particular situations. Any state can be completely managed by center in the emergency situation. Let us move ahead now. After understanding the meaning of emergency, we will now look into the provision of Indian Constitution. Well, basically, there are three types of emergency which are mentioned in the Indian Constitution. That is national emergency, state emergency, and financial emergency. The provisions are from Article 352 to Article 360 in Indian Constitution. Article 350 talks about national emergency. Article 356 talks about state emergency, and financial emergency has been provided in Article 360. First of all, we will discuss the national emergency, which is one of the most important topic in the Constitution of India. It has been contained in Article 352 and Part 18 of the Indian Constitution. This emergency provides that if the President is satisfied that a grave emergency exists whereby the state of India or any part of India is threatened by war, external aggression, armed rebellion, then the President may make a proclamation of emergency in respect of the whole of India or any part of it, as may be specified in the proclamation. So on by reading the plain language of the Article 352, we understood that there are three things that if these things happen, the President may proclaim emergency: war, external aggression, and armed rebellion. A proclamation of emergency can be made even before the actual occurrence of the emergency if the President is satisfied that there is an imminent danger of war or external aggression or armed rebellion. Thus, actual occurrence of an event mentioned in Article 352 is not essential. An imminent danger of war or external aggression or armed rebellion is also adequate for proclamation of emergency. The President shall not issue a proclamation without consulting the Union Cabinet, therefore the Council of Ministers and the Prime Minister. Such proclamation may be issued, has been communicated to him in writing. The main important point, that has to be in writing. This means that the emergency will be declared only on the conformity of the cabinet and not merely on the advice of the Prime Minister. Well, now we will see that how far Article 352 has been applied in India since we have adopted the constitution, since the independence of India. Well, uh, there have been three proclamation emergency till now. First, in 1962, at the time of Chinese aggression. Second, in 1971, when we were war with Pakistan. Then third, in 1975, on the ground of internal disturbance. Well, there was a major shift. Well, I will not say shift. Well, there was a major amendment which changed certain words in the Article 352. So we will now understand what was that word and what was which word it was replaced. The word armed rebellion was substituted with internal disturbance. Clause 3 was added in Article 352, which states the president shall declare emergency only on written advice of cabinet. And this was done after the case of Indira Gandhi versus Raj Narayan. Before 44th Amendment Act 1978, a proclamation of emergency could remain in force for 2 months in the first instance. But once approved by Parliament, the emergency could remain in force for indefinite period of time as long as the executive wanted it to continue. The 44th Amendment had curtailed the power of executive to extend the operation of emergency unnecessarily. After 44th Amendment, a proclamation of emergency could remain in force in first instance for 1 month. Such proclamation, if approved, shall remain in force for the period of 6 months unless revoked earlier. The resolution approving the proclamation must be passed by both the houses of parliament by special majority, that is by majority of total member of each house and also by majority of not less than 2/3 of the member present and voting in each house. For further continuance of emergency beyond the period of 6 months, approval by parliament would be required every 6 months. If the proclamation is issued at the time when the Lok Sabha has been dissolved or dissolution of Lok Sabha takes place during the period of 6 months without approving the proclamation, then the proclamation remains until 30 days from the first sitting of the Lok Sabha after its reconstruction. Well, now we will understand the effect of emergency, like what happened after the emergency has been placed. What will be the effect on the political setup? What will be the effect on the fundamental rights of the people of India? So the effect has been divided into three categories. A proclamation of emergency has drastic and wide-ranging effect on the political system of the government. The consequences has been grouped into three categories. First category is effect on center-state relation, effect on life of Lok Sabha and Rajya Sabha, effect on fundamental rights. While proclamation of emergency is in force, the center-state relation undergo basic changes, and this has been headed under, like it has also been divided into three categories. First is executive. During a national emergency, the executive power of the center extends to directing any state regarding the way in which its executive power is to be exercised. In normal times, the union can give executive direction to the state only on certain specified matters. Thus, the state government are brought under the complete control of the center, though they are not suspended. Legislative. During the national emergency, the parliament is empowered to make law on subject matter mentioned in the state list, though the legislative power of the state legislature is not suspended. It becomes subject to the overriding power of the parliament. The laws made by the parliament on the basis on the state matters will not be functioning after the emergency cease to operate. Financial. While proclamation of emergency is in process, the president can either reduce or cancel the transfer of finances from the center to the state, or such order of president has to be laid before both the houses of the parliament. Effect on the life of Lok Sabha and State Assembly. While proclamation of emergency is in process, the life of Lok Sabha is also extended beyond its normal term by law of Parliament for 1 year at a time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. Similarly, the Parliament may extend the normal tenure of State Legislative Assembly by 1 year each time. During a national emergency, subject to a minimum period of 6 months after emergency has ceased to operate. Effects on fundamental rights. This is the major important effect which we all need to understand, that what will be the effect of emergency on the fundamental rights of the Indian citizens or the Indian nationals. Article 358 and 359 set out the effects of national emergency on fundamental rights. Article 358 deals with the suspension of the elemental rights guaranteed by Article 19, while Article 359 deals with the suspension of other fundamental rights except guaranteed by Article 20 and Article 21. So Article 359 gives the power not to suspend Article 20 and 21 and to suspend other fundamental rights. Even at the time of emergency, we have Article 20 and 21 alive. Suspension of fundamental rights. According to Article 358, when a proclamation of emergency is formed, the 6 fundamental rights under Article 19 are automatically suspended. No separate order for their suspension is required. The Amendment 44th in 1978 restricted the scope of Article 358, providing that the 6 fundamental rights under Article 19 will be suspended only in the situation of national emergency is asserted on the ground of war or external aggression and not on the ground of armed rebellion in the country. Next, we have suspension of other fundamental rights. As per Article 359, the President is authorized to suspend the right to move any court for the enforcement of fundamental rights during national emergency. In other words, the fundamental rights are not suspended as such, but only their enforcement. The suspension of enforcement relates to only those fundamental rights that are as per the presidential order. Now, let us understand what is state emergency. We have understood the national emergency, the effect of national emergency. We have understood, we have read the provision of Article 352 also. Now 356 says that President can act on report of the governor or otherwise is satisfied that the situation has arisen in which the state government is unable to perform its duty in accordance with the provision of the Constitution. He may issue a proclamation. This concludes that the President can also act even without governor's report. Article 355 justifies it by saying that the center is obliged to ensure that the government of the state is carried on in accordance with the provision of Indian Constitution in certain circumstances. Proclamation by President is called proclamation due to the failure of constitutional machinery in the state. By that proclamation, the President may assume to himself all or any of the power vested in the governor or exercised by him to anybody or authority in the state. The President may declare that the power of legislature of the state shall be exercised by or under the authority of Parliament. The President may make such consequential provisions as may appear to him to be necessary or desirable for giving effect to the subject of proclamation. Parliamentary approval and duration, one of the major important point. A proclamation shall laid before each house of the Parliament for approval and shall remain operational for 2 months. After the expiry of this 2 months period, the proclamation ceases to operate. If the proclamation is issued at the time when the Lok Sabha has been dissolved or dissolution of Lok Sabha takes place during this period of 2 months, without approving the proclamation, then the proclamation survive until only 30 days from the first sitting of Lok Sabha after its reconstruction. If the proclamation is approved by the parliament, it will remain in operation for 6 months. Parliament may extend the duration of proclamation for 6 months at a time. No proclamation shall remain in force more than 3 years. After the expiry of maximum period of 3 years, neither the parliament nor the president shall have power to continue a proclamation, and the constitutional machinery must be restored to the state. Then there is a major case law, S.R. Bommai versus Union of India. The facts of the case are: on December 15, 1992, President rule was imposed in 3 BJP-ruled states, Madhya Pradesh, Himachal Pradesh, and Rajasthan. And assemblies were dissolved on the ground that these states were not implementing sincerely the ban imposed by the center on religious organization. The main ground on which the government had been dismissed was that the chief minister of these states has connections with an organization which has banned and been banned, and secondly that these government had encouraged the Kar Sevak to go to Ayodhya. Thus the premise was mere suspicion, and they might refuse to enforce the ban. There were no proof that they were not following the direction of the center. So this was done on suspicion basis, not with proof in their hand. It was held the dismissal of the government in Madhya Pradesh, Himachal Pradesh, and Rajasthan in the wake of Ayodhya incidents in December 6, 1992 was valid, and imposition of president rule in these states were constitutional. Secularism is a basic feature of constitution, and any state government which acts against the ideal of this principle shall be dismissed by the president. It was held in the matter of religion, the state has no place. No party can simultaneously be a non-secular party as well as a political party. Then come to the financial emergency. It has been provided in Article 360 of the Indian Constitution. It empowers the president to proclaim a financial emergency if he is satisfied that a situation has arisen where the financial stability or constancy or credit of India or any part of its territory is threatened. In other words, it means whenever the president is contended that the economy of India is in danger, he may proclaim the financial emergency. Parliamentary approval and duration of this type of emergency. A proclamation declaring financial emergency must be approved by both the houses of parliament within 2 months from the date of its issue. It survives until 30 days, just like its preceding emergency, from the first sitting of Lok Sabha after its reconstruction, if at the time of proclamation the Lok Sabha was dissolved or the dissolution of Lok Sabha was taking place. Once the proclamation is approved by both the houses of parliament, the financial emergency continues indefinitely. Its time is unspecified till it is revoked. The repeated parliamentary approval is not required for continuation like the other 2 emergencies. This is like a unique feature of this emergency. A resolution approving the proclamation of financial emergency can be passed by either house of parliament or only by simple majority. Therefore, a majority of members present and voting of the house. It can be revoked by president anytime by a subsequent proclamation. Those proclamation does not require parliamentary approval. What are the effects of financial emergency? Let us understand that what will happen in the country or who will be affected by this type of financial emergency. The implication of financial emergency are the president may reserve all the money bills or financial bill after they are passed by the state legislature for maintaining financial consistency and credit of nation. President may issue direction for reduction of salary and allowances of all or any class of persons serving in the state, all or any class of persons serving the union, the judges of the Supreme Court and the High Court. That thus, during the proclamation of financial emergency, the union acquires full control over the state in financial matters. Let us now conclude the whole provisions which I have studied. So by after having understood the three type of emergency, the national emergency, state emergency, and the financial emergency, their effect on the fundamental right, or what will change in the country after this emergency or any the type of emergency which has been explained, what will be the effect we have understood. Now what have we concluded from this? Like, emergency provisions were amended under the constitution for the security of the country. They were given in the this for the security and for the protection of its people. But these provisions delegates excessive power to the executive, which we can see in the provisions of the Indian Constitution. This affects the federal character of the Constitution. Like, if excess of everything is bad, so this affects the federal character of the Constitution, and the union becomes all powerful. Although the need for emergency provision is understood, but there are some changes required in the mechanism so that there is no violation of fundamental rights of the citizens, and there is no misuse of power vested to the executive for their political purpose. So in the conclusions, we understood that yes, emergency provisions are mentioned in the constitution. They are for the protection of the people. On the other hand, by giving the excessive power to the center, we are giving scope to the executive to use it incorrectly. But then it does not happen. It has not happened, and it will not happen in future also. But there is a scope of misuse of power vested to the executive for their political purpose, because at the end, we all are humans. We have good thoughts, we have bad thoughts, so it can be misused. So there is a scope of improvement. By this, I hope you all have understood well, and I conclude my lecture. Thank you.